Hello, my name is Zach Bass, and I'm the editor-in-chief of the NYU Journal of Intellectual Property and Entertainment Law. And this is, again, the Author Series. This episode is going to be about line drawing, specifically the grayest line in all of intellectual property and maybe even in the law itself, and that is the line between imitation and innovation. In the law, we use the fair use doctrine to draw these distinctions, and whether a copyrighted work is fairly used can result in awards of millions of damages and sometimes can actually result in careers being created or even ruined. In 2008, Professor Barton Beebe published the first empirical analysis of the fair use doctrine. To do so, he read every fair use opinion from 1978 to 2005 while paying attention to specific trends, specifically which of the four fair use factors was the most associated with a finding of protection. This article has since become very influential. It's been cited hundreds of times, including by at least one filing brief in this year's Supreme Court case, Google versus Oracle. Also this year, Professor Beebe decided to update his analysis and publish his article in a second edition in this journal. Thus, his article now spans nearly 600 fair use opinions from 1978 to 2019. Since his last study, he's seen some interesting trends. Amongst them is that the Second Circuit is becoming less influential in interpreting the doctrine over time, and that more and more courts are actually issuing summary judgment decisions, which could mean that the courts are becoming more comfortable in using the fair use doctrine itself. Now, I know what you might be asking. Why should I care? Well, I can think of a million reasons why you should care, but for your sake and mine and for the length of this video, I will go ahead and stick to two. The first is that many industries are reliant upon how the courts interpret this doctrine. One example would be modern art. From the early 20th century with Duchamp's fountain, to Andy Warhol's silkscreen prints, to Jeff Koons' sculptures, to literally everything Richard Prince has ever done, copying has become an art form in and of itself. Thus, how the courts interpret this doctrine could actually determine whether an artist creates in the first place. The second is sort of my own interpretation of the doctrine. I see fair use as the law of creativity. It requires courts to make creative judgments. In order for a work to earn fair use, it has to be creative enough. Thus, when you read Beebe's article, one could see it as a narrative of society's conception of creativity itself. I found this to be an awesome interview. Professor Beebe actually taught me. I think he's a great interviewee. I hope you think so too. And once again, my name is Zach Bass with the NYU Journal of Intellectual Property and Entertainment Law. Enjoy. So hello everyone. I'm here with Professor Barton Beebe. He's the John M. Damaris Professor of Law at NYU School of Law, where he also serves as co-director of the Engelberg Center on Innovation Law and Policy. He has been published in Harvard Law Review, NYU Law Review, and so on and so forth. And he is also an author on trademark law, a casebook on trademark law that is now being used by over 50 law schools around the world. This is a particularly special episode for us because Professor Beebe has served as faculty advisor for this journal since its very inception over 10 years ago right now. And I've also had the pleasure of taking a class with Professor Beebe, so I can attest that he's a great guy. So thank you very much, Professor, for being with us.
Oh, my pleasure.
All right. So I thought as a first question, I'd sort of throw you a little bit of an alley-oop. And the question is, you know, we live in a world with Westlaw and Lexis, right? Empirical analysis of legal doctrines have never been easier. So I guess my question to you is, then why do empirical analysis with fair use? Why do you feel that an empirical outlook of the fair use doctrine is valuable to judges, lawyers, students, and professors?
Yeah, so I think an empirical analysis of the fair use test, the four-factor test, is useful to everyone who's involved in the copyright law and policy making, because for decades there had been speculation about which factors in the four-factor test were the most important factors, which were irrelevant. How did courts use the factors? Were the factors used slightly differently in different circuits than in other circuits? And it seemed to me that simply engaging in case counting, like the old, the old exercise of case counting, so-called systematic content analysis, could help to answer these questions. I wouldn't for a second say that this method settles those questions and answers them entirely, but it certainly provides a lot of good information to help us understand how this test works. And I guess the larger answer is that the copyright fair use is incredibly important to the entertainment industry, to the content industries in general, the culture industries, if you want to call them that, and also to like the non-industry people such as myself who produce content, post it online, and want to know if they're allowed to appropriate the expression of others. So all of those factors combined made it seem like an empirical study of the fair use four-factor test would be, useful. I mean, it's not like the be all and end all of legal studies, but I thought it would be useful for those of us who worry about fair use.
And I think, just from reading your article, it's certainly useful. And I think the other thing that I found in reading your article was I was overwhelmed by its thoroughness. Right now this article is analyzing close to 600 fair use opinions since the 1970s. And, in order to make sure that the data that you're using is good, we went ahead and looked at the data and validated it. We only took a sample size of about, I think, 35 cases to do this. It's taken us a month to validate those 35 cases.
Yeah.
So I just find it incredible that you put this much time into this. So I guess my question to that is, what motivated you to do this? I mean, did you know it was going to be this time consuming from the very beginning?
Yeah, so the original study that looked at the fair use federal case law from 1978 to 2000 through 2005 was only like 330 opinions. And so I say only 330 opinions, but it seems, I don't know, vaguely manageable at the time to read the opinions and just code how each of the four factors went, like in favor of fair use or against fair use or neutral. And then, of course, any empirical project of this nature, like case counting, invariably, like more variables get thrown in. Like people ask questions, well, what about that little issue? Or what about this? And so I guess I didn't know going in just how much work it would end up taking. But what's, I guess, has been nice is that I've been updating the data set every year with the help of research assistants, so that bringing the study up to date through 2019 was like monotonous and mind-numbing at times, but it wasn't as though I sat down and tried to code 579 opinions in one go. It was sort of little blocks of opinions each year to update the data.
So I guess the most common sense question after that response is, why choose to publish a second edition now?
Yeah. So I've been, like I say, updating it all along, just almost out of curiosity. Like after the original study was published in 2008, and again, it studied the case law through 2005, I thought, oh, well, I should just keep up with it on my own just to see if the trends continue or if they change. And then I thought, oh, it would be worthwhile to publish an update. Other people had taken the method and published shorter term updates. And I thought, well, it might be a good idea to publish a full-on update of the full data set. And I thought it would be good to do it like for maybe like a nice round number, like 40 years, so through 2017. And then, to be honest, other projects just kept taking priority, especially with my co-authored projects, where I couldn't really say to the co-author, no, I've got this little thing going and I can't see you for a year. So I put it off, and then eventually now seemed to be the time, especially with Google v. Oracle, or the Oracle case in front of the Supreme Court, which might engage fair use. It might not reach the fair use issue, but it seemed like now might be a good time to at least consolidate my findings.
So let's start talking about what's stayed the same since your last edition. And that's something that I find incredible is, as we know, for anyone that's learning this fair use doctrine, you learn these are the four factors, but they're not equal in strength whatsoever. That usually the first factor and the fourth factor are going to be the most valuable. For example, one of the statistics that I found so interesting was in 92% of cases where the court found that the first factor was met.
Yeah.
Fair use is found, right? Yet, in the 12 years since you published, since this last study, courts are still using this test mechanistically when there's no point. I mean, when you really look at the statistical analysis, it's really the first and fourth factors that matter. So I guess in your opinion, what do you think about this? I mean, do you think
Yeah.
it's this mechanistic approach? Is this a useless exercise?
Yeah. So it's a good question. Totally a fair question to be asked of this four-factor test. And it reminds me, another reason I was reluctant to publish an update until finally now was this feeling that not a lot has changed over the years. And there's not much of an incentive still in the social sciences or in law to publish like negative results. Like I studied it and found nothing, and no one wants to hear that. So, but I think in the fair use context, as your question emphasizes, actually, it's very interesting results that courts are continuing to engage in a fairly mechanical application of the four factors. I think, though, that the four-factor test is actually really useful, and even the mechanical rhetoric courts use is not as much of a problem as it might appear to be. And I think the thing to keep in mind is that the federal judges are generalist judges. In a single day in a district court, the judge is dealing with quite possibly like 20 or 30 different areas of law. And she can't be expected, or he can't be expected to be a specialist in each of these areas. So fair use as an equitable doctrine is very, vague. And these four factors instituted in the statute, I think, give some guidance to the courts to almost like a checklist. Like we realize that, in this checklist, certain issues are far more important than others, but it's still worthwhile to take all of these things into account before the judge comes to a final conclusion. So my defense of the four-factor test is based on the experience of a generalist judge, having clerked in a district courts in the Southern District, having seen that, and the need for guidance to non-specialist judges, though admittedly SDNY judges definitely tend to be fair use specialists. The test is very helpful to sort of constrain the wide open nature of fair use.
And I definitely want to ask about the SDNY a little later in the interview. That's so incredibly interesting. But, I'm noticing that you and we keep talking about the four-factor test. But when you read the Copyright Act, that's not what it says. The Copyright Act allows judges to think of factors outside of these four. But another thing that your study shows is since 2006, I believe, only 5% of cases have ever looked at any factors outside of these four. Do you find that, that's a very stringent test. That's a very narrow test when you really think about it. From what you know of fair use, is that consistent with what Congress wanted? When I think of fair use, I think it's the law of creativity. And this just doesn't seem like a very creative doctrine to address that subject matter.
Yeah, so it's definitely the case that the framers, I call them the framers, let's just say the people responsible for the four factors, Section 107 of the Copyright Act of 1976, I think they had a strong hope that the four factors would just be the start of the court's analysis, and that over time courts would add in other factors and maybe depart a little bit, notwithstanding what I just said about how the factors are helpful to constrain the wide open nature of fair use. Still, I think the writers of the four factors hope that courts would treat them a little more flexibly, possibly, than it may appear that courts are treating them. But keep in mind, in defense of the four factors now, I guess I would propose that underneath each of the factors, it turns out that courts' use of the factors has been reasonably, somewhat flexible. Like factor one has come to incorporate the good faith consideration. Factor three now incorporates the necessity question, like did the defendant use more than was necessary? So I don't have a clear sense in my own thinking of like how to answer your question other than to say, yes, it's disappointing that courts have tended to use the factors still fairly mechanically. But pushing back on that, there does appear to be a tradition of flexibility underneath each, within each of the factors.
So this this might be a bit of a challenge to your article a little bit, to one of the findings. And I'm curious to hear
great.
what you think. So you essentially conclude, and I don't want to put words in your mouth, but you essentially conclude that it still appears that the fourth factor is the most important, that it's at least has the highest correlation of success on the fair use analysis. However, you also do a very interesting study looking at word counts, and that you look into, okay, how much time is the judge looking at each of these factors? The first factor wins out on that. The first factor, and it's almost twice as much as the fourth factor. So what do you have to say about that? I mean, when I read that, I think, well, wait a minute. It sounds like the first factor, it might be more important.
Yeah. No, that's a really good point. And I think the first thing I should say is, like, I've wondered about that as well. And I think people who can think a lot about the fair use four-factor test think about this as well. Like, a lot of the scholarly attention is on the first factor. It's also on the fourth, but transformativeness doctrine under the first factor gets quite a lot of attention in the legal academic literature and also in court opinions. And I think the figure in the paper shows, the proportion of fair use analysis devoted to factor four has been sort of steadily declining, over time. Still, though, I think as I say in the paper, factor four it's like less of a factor among the four factors as it is a meta factor, like a summary factor. It's like, having considered the previous three, now let's balance those against the impact on the plaintiff's incentives to create its work. And the fourth factor does that balancing test sort of on the home turf of economic rhetoric or economic analysis, whichever way you want to put it. And on that home turf of the economic, that seems to be an area that's a mode that benefits plaintiffs typically, that works to the disadvantage of the public domain or to defendants. But so I sort of I stick by it that the fourth factor is still the leading factor, but I guess what that's really saying is the economic approach is still the dominant approach. And even though courts might spend more words talking about the first factor and transformativeness, the fourth factor is where sort of like the rubber hits the road, and the court ultimately decides how this determination is going to come out. I refer to it as being in like the cleanup position in reference to baseball as the fourth hitter. But what would be really interesting is if in some alternate reality, the first factor on transformativeness actually came last. And so the court, let's say, began with the economic consideration and then weighed that against the defendant's justification. Would that sort of change the test somehow? We'll never know. We don't live in that alternate reality. But I think it's reasonable to assert that if the ordering of the factors had been different, there, in very close cases, we might see some different outcomes. I did a different study on multi-factor test in the trademark context. And there it was really, as a matter of like whatever, cognitive science or the rest, like how people use multi-factor tests, the ordering of factors is sort of a platitude in that world, that yeah, of course, the ordering of factors can have a big effect on how the test ends up getting applied.
Very interesting. And it is funny to see, or I think the better word would be ironic, that the fair use doctrine has become so commercial in focus, because as you also say in the article, the Southern District of New York is it's still the dominant federal district court around the country. I think you analyzed about 433.
Oh, is that right? Okay, yeah.
I think so. Federal district court opinions since the 1970s, and over 100 are from the Southern District. I think second place is the Central District of California with 45. Were you surprised to see that continued dominance, since your last study? Because I mean, we live in the internet age, and you immediately think Ninth Circuit,
Yeah,
California.
yeah. I was, I was, I guess, not surprised, but that's just because I clerked in the SDNY for an absolutely excellent judge, and I'm proud of that. If it's not clear, like I think it's a great district court. It's a really good expression of the success of the federal courts and the support as an institution for the rule of law and all that stuff, which I believe, And so as a result, I came to this project already with a bias or like a prejudice towards the SDNY. And even in my own little experience there, definitely you saw a lot of copyright cases. So a lot of, even, the tech world, of course, has exploded in significance since the late 1990s. But there's still an enormous other area of copyright law that it does not involve high technology or computer code, but old-fashioned, human readable expression in books or in movies. And so I guess I was not surprised because I had seen so many copyright cases while I was there. And just as outside of the systematic analysis, just as an impressionistic matter, a lot of the cases I had been reading as a student or early on were all from the Second Circuit or the SDNY. But the Ninth Circuit is definitely starting to gain significance. And we'll see if that has any big effect in the long term on the on fair use policy in the US. But don't forget also the Second Circuit does have high technology cases. I'm a former Northern Californian. I grew up in the East Bay of San Francisco, but I'm sensitive to these Californians who keep thinking like they're the only people who do tech. And in fact, the technology corridor along the so-called Acela corridor is actually quite vibrant, especially between, from New Jersey to Boston without question. And so we get a lot of tech cases over here as well.
And what do you when you think of where fair use is going, how do you think? I mean, do you see Google v. Oracle having sort of any major impact on this doctrine? I mean, do you anticipate any changes?
Who knows? I think it's an incredibly hard case, actually. And I have to admit, I didn't sign on to any of the briefs on one side or the other because I just, like myself, wasn't sure of what the correct outcome was. Like it's that hard of a case, though. I do think that the subject matter asserted by Oracle should not qualify for copyright protection. But if it does qualify for copyright protection, I'm not sure that what Google did with it was fair use, and that's the problem. But even there, this is all now to answer your question, like what you actually asked is. The first answer, I don't know. I really don't know what could happen. I'm quite concerned that the Supreme Court opinion in the case will possibly reset fair use, but now in the context of high technology. And as a result, maybe diminish the subtlety of the doctrine with respect to non-high technology forms of expression. So it seems to me that it's a little dangerous if the future of fair use is established with respect to computer code or to APIs. And whatever the court writes in that context will then sort of invariably get transferred over into movies or books or poetry or academic research. And it can be worrying that big grand statements in one area might not work the same way in another area. But I wish the court luck. We'll see what they do with it.
Same sentiments.
Yeah.
Trust me. So I feel inclined to get into politics.
Yeah.
So for those that are watching this, we are filming this on November 10th. A new president has just been appointed. And I think and this is my own personal opinion, I think one of the sadder developments that we've seen over the last 20 years in politics as its invasion into the judiciary, that we haven't seen this low level of trust in the judiciary in some time. And I think it's likely because people think that these judges they're going to decide exactly the way that their appointees chose them, that they're going to be influenced in this way. Well, I'm happy to say that's not the case with fair use. I thought that was probably, without a doubt, the most interesting thing in your entire article. So, according to your article, fair use appears to be immune from political influence. There's really no correlation that exists between a judge's possible, we don't know. Just because a Republican Congress, puts them forward, we don't know if they're going to decide in that way. But still, there's no correlation. And there's really no statistical significant relationship between the judicial circuit and the finding of fair use. So I guess, could you briefly explain to the viewers, what variables did you look into for this? And were you surprised to find basically no relationship?
Yeah, so I looked at sort of the usual variables when we're studying judge characteristics and outcomes and opinions, or uses of doctrines and opinions. So I looked at political ideology, judges' age, gender, race. I didn't go much farther than that because just on those factors alone, I wasn't finding any sort of significant results. So here was like a negative result I'm reporting that was just like, nope, didn't find anything. And as far as political ideology, I used various approaches to estimating the judge's political ideology, like the party of the appointing president, or a more sophisticated approach, which is the judicial common space developed by other researchers that relies on the ideology of the appointing president and the appointing senators for the state in which the federal court sits. So I was not surprised that there was no correlation, between ideology and outcomes in fair use. I think copyright law it's not one of those areas of the world that has a valence. Like if you tell me what you think about environmental policy, gun control, and reproductive rights, I can probably predict like quite a lot of other views you might have in politics. But copyright policy doesn't quite fit in yet to that framework, So, I mean, at the moment, we're in a world where like whether you wear a mask or not is suddenly like an ideological statement. So just about anything, it seems, could suddenly be ideological. But copyright law has not yet like been gripped by that. Furthermore, keep in mind that the Democratic Party, one argument, I'm not sure I believe this, but one argument is that to the extent that a lot of their financial support comes from the entertainment industry, they might be copyright property rights and anti-fair use. That's sort of crazy because depends on what part of the entertainment industry you're talking about, just as it depends on what part of high tech you'd be talking about to come to that conclusion. But this is all to say that the politics around copyright policy and fair use are pretty jumbled. Also, libertarians, to the extent that they are associated with the conservative movement, and maybe they shouldn't be for good reasons, but libertarians can be anti-copyright protection because it's, well, we need not go into it, but so that can further complicate matters, where it's actually some libertarian judges in the Federalist Society tradition whom we might rely on as the most stridently anti-copyright, pro-public domain because of other political commitments they have. But all of this is still bubbling around. It hasn't really locked in yet.
And were there I'm always interested in the authorship process and how so many ideas can come out of it. Were there any sort of discoveries through this article that, have inspired you to pursue another piece? And if so, on what topic?
So I was really grateful to your staff to your team for checking all the data and going through it again. I was having like these traumatic flashbacks to how monotonous it can sometimes be to code these opinions, and how error prone the process can be unless you like really chain yourself to the desk and focus and concentrate. So this is all to say, I can't imagine, I will continue to update the data as the years go by, just out of habit now, and just out of just personal curiosity and the fun of being the first person to see the results, which are like always the same so far, but whatever, maybe they'll change. But I don't anticipate doing anything more on fair use. I've written a few other little things on fair use and like little aspects of fair use, but there are other scholars who I think are like much more attuned to the subtleties of fair use, not from this systematic content analysis method, but from actually like old-fashioned methods of reading the opinions and thinking hard about what they say and then looking at policy choices made in those opinions. And I'm not sure I have much to offer to that angle. So I think I'll continue this project, but will probably not come back to fair use unless Google v. Oracle does something extraordinary, but we'll see.
Interesting stuff. Well, I think I speak on behalf of my whole staff when I say it's been an honor to work on this piece.
Oh,
it's been
thanks.
incredibly insightful.
Yeah.
And I think so many lawyers and judges and academics would find this to be crucial reading, I think, in understanding the fair use doctrine. So thank you, Professor Beebe, for this article. Thank you very much for this interview. And I think I speak on behalf also of the entire legal community in that we're looking forward to what you have next. So
yeah, well, thanks. The reason I wrote this was basically for lawyers and practitioners. So I'll tell you, when this study was mentioned in the oral arguments in the Oracle case, that was like made it all worthwhile. Because this is, if it can be helpful to actual practicing lawyers, even modestly helpful, then it's been worthwhile. And so, yeah, so thanks for putting it in those terms, because that's how I see it. And thank you for all your work on this as well. And I'm looking forward to seeing it in print pretty soon.
All right. Thank you very much, Professor. Good
Okay.
stuff.